What I have for you today is an interesting case about intercompany loans from Latvia. Now, here you can see the decision, and a big warning from my side. I do not speak a word of Latvian. I do not know how to pronounce a lot of the words on the slide, and I rely wholly on Google Translate for the accuracy of this translation. Why do I discuss the case? I think it's interesting, and it's been sent, or I've been made aware of it by a viewer of my videos, Edgars Hercenbergs from Rödl Partners, and thank you for that. I would like to discuss this case with this caveat about the language. A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. So what is it about? It's about a group called the Baltic Mill, which does a lot of grain products in the Baltics, and they are run by the Baltic Mill Group in Lithuania, which then owns two other companies in Lithuania, UAB Malinvest and UAB Malsena Plius. And they've got, and Malinvest has a subsidiary in Latvia, the Rrīgas, the company that we're talking about. And Rrīgas got loans from Malinvest of 5.8 million at a fixed interest rate of 6%, and from Malsena Plius at 3.4 million at a fixed interest rate of 6%. And the tax authorities said that these rates were too high. So let's see what the timeline of this procedure is. You had the first loan in 2013 in March. Then you had an audit at Rrīgas covering the period from July 2013 till June 2014. I assume that will be their financial, at least their tax year. You had the second loan issued during the audit. The assessment was made in June 2016. The district court, the court of first instance, annulled the assessment in 2018, saying that it was within the range, and the Supreme Court that we're looking at now annulled the district court decision and sent the case back to the district court. And just some of the dangers of translating through Google. Google referred to the district court both as a district court and a regional court, so it took some time to realize that this was one in the same court, and this was not a third level of appeal that we're looking at here. If we look at the district court's decision, it raises a number of interesting points. The first one is both parties applied the CUP method, which is provided for in the Cabinet Minister Regulation of 2006. Therefore, the district court does not have to justify the choice of this method, and they move on and say there is no publicly available information on specific lending transactions of non-financial institutions. Transactions of financial institutions are also confidential information. Accordingly, the way to find out the approximate content of transactions is statistical reports. Both parties use statistical data of the Bank of Latvia. And I think this implies a couple of things. First of all, these were probably loans in Latvian currency. I don't know if that is, yeah, that must be euros then. And that's why they could use the information from Bank of Latvia. I don't know if there are special requirements in the Latvian legislation saying you must use local comparables, or whether they could have, for instance, used ECB comparables instead. But they used the statistical data from Latvia, and that data obviously was anonymized. So the court goes on to say, the district court, in the transfer pricing calculation examples available on the website www.transfercenas, I assume, the comparative price takes into account the median of prices, not the average of prices. And this is important because we talk about industry average. Industry averages hereafter, but of course the question still is whether a median of a whole country's loans is not an industry average in itself, right? It's also interesting to see the court going on to a commercial website, the Transfercenas, to actually determine what the median is, because what it says next is, after examining the statistical data of the Bank of Latvia, it can be established that the median interest rate of 3.71% in December 2012 comes from an interest rate of 1.3 to 6.79%, and in December 2013 from 2.9 to 7.8%, producing a median of 4.32%. And remember, the loans were both at fixed rates of 6%, so these are both within the range. And then just to show the range physically here, you can see 3.71 looks like it's almost in the middle between 1.3 and 6.79, but clearly 4.3 is not, and that makes me assume that these are medians, not averages. If we continue with what the court says, the court then refers to the transfer pricing guideline and says, however, considering the explanations of the service in another case, which they don't mention which, and paragraph 135 of the 2010 transfer pricing guidelines, unadjusted industry average reporting data does not by itself provide arm's length conditions. And so in other words, the bank's statistical data is not enough. Therefore, the statistical data collected by the Bank of Latvia cannot be directly used for price comparison. And then to understand what's going on in the case here, the court hereafter asked for more data from the Bank of Latvia, and the Bank of Latvia said, here you are, you can have a look at it, but because of confidentiality concerns, you cannot show it to the parties, only you can see it. And this is one of the things, or this is the thing that went wrong in this case. I think it's also interesting that the court uses the 2010 transfer pricing guidelines. I think this must be based on the idea that since the transactions happened in 13 and 14, the 2010 guidelines were the latest ones that were published, and the court ignored, or at least did not quote, the 2017 guidelines, even though its decision was in 2019. For those of you who regularly look at this case, at my case law, you'll remember that there was a Belgian Dempe case as well, where the Belgian court said that they could not use to the 2017 guidelines, which explained the Dempe functions, because the transaction happened before 2017. And then that court, as a matter of interest, went on and used the Dempe criteria nonetheless. So what does paragraph 135 say? It says, all methods that apply the arm's length principle can be tied to the concept that independent enterprises consider the options available to them, and they consider any difference between the options that would significantly affect their value. So they look at everything. They don't only look at the one intercompany transaction, right? Therefore, as discussed in chapter 2, part 2, about dealing with methods, the comparable uncontrolled price method compares a controlled transaction to similar uncontrolled transactions to provide a direct estimate of the price. However, the method becomes less reliable if not all the characteristics of these uncontrolled transactions that have significantly affect the price charged between the independent prices are comparable. Right? So they must be comparable. Where there are differences between the situations being compared that could materially affect the comparison, comparability adjustments must be made where possible to improve the reliability of the comparison. And then we come to the sentence that we're talking about. Therefore, in no event can unadjusted industry averages return themselves, industry average returns themselves, establish arm's length conditions. And this paragraph since 2017 is actually paragraph 140. But again, you cannot use industry averages. And it's interesting decision for the court here, because if it is common practice in Latvia to use the Latvian bank statistical reports to benchmark loans, it basically means you cannot do that anymore unless the Bank of Latvia is going to publish some of the other information that you need, right? And the court then concludes, this is the district court, the service had to perform mathematical calculations and acceptably accurate corrections of financial data to exclude the significant impact of the differences found on comparability factors. It did not, although it is generally recognized that the interest rates are lower for collateral loans collateralized loans, and that variable interest rates increases the interest payments. And apparently the loans between Malinvest and Rrīgas and Plius and Rrīgas were not collateralized. However, the court goes on to say, since the applicant's interest rates generally correspond to the interest range of the loans of the used for collateralized loans issued by financial institutions, there is no reason to redecide on the evaluation of the transfer prices, right? So clearly the bank used collateralized loans, which would be expected because banks normally do use collaterals, and the court, even though it said that there is a difference between collateralized loans and uncollateralized loans, it went with this range and said that the uncollateralized loans are within the range of the statistical collateralized data, is what it seems to be the case. And the tax authorities appealed this because they lost the case, because the court said there's no need for adjustment, the 6% interest is within the range. The services filed a cassation complaint citing the following arguments, and some of the English here may not be idiomatic. I've left it as it is because I'm not quite sure what the underlying Latvian text where it puts its emphasis, but it goes on to say, "It follows from a judgment that the Court of District had more detailed information which was not available to the parties." And this is true because they asked the Bank of Latvia for the further data. The District Court stated that the statistical data of the Bank of Latvia at the disposal of the parties to the case cannot be used because it is not possible to determine the essential details of comparable transactions from them. Now, the court did look at what the tax authorities did and said, you know, we could clearly see how they got to their percentage because they used this website apparently and then used the medians and determined the ranges. It said of the taxpayers' files, it said, you know, we have no idea how they got to the 6%. Because it seems as though they used the data from the Bank of Latvia, but they simply cherry-picked the data and used what got them to the 6% without explaining any systematic approach to that data. So that's just part of the background here. And then the tax authority says, in addition, the district court assumed that secured loans have lower interest rates. However, UAB Malinvest indirectly owned all the taxpayers' assets, making collateral of little importance because the Rrīgas was 100% subsidiary, I assume, of Malinvest. It was a subsidiary. The question is if it's 100%. Thus, the district court had to find the absence of collateral an immaterial comparability factor. So the tax authorities basically say, you know, if it is a subsidiary, your debtor, you should always assume that the loan is collateralized and therefore the interest rate should always be lower. It would be interesting to know if they use that same argument for outgoing loans from Latvia. And then the Supreme Court responds, and the Supreme Court says, the Supreme Court reminds the parties that according to the principle of procedural justice, the court must give parties a proper opportunity to express their opinion, including participating in the examination of evidence. In other words, the court says they should have seen whatever it is the Bank of Latvia gave the court. And then they say even the European Court of Human Rights has also emphasized this. It is part of the right to a fair trial in Article 6 of Paragraph 1 of the European Convention on the Protection of Human Rights and Fundamental Freedoms. And apparently this was recently decided in a case against Latvia, which might be interesting to look at some point. That's the Valentina Vorodnikova case. And then the Supreme Court goes on to say, yeah, but however, Article 145 of the Law of Administrative Procedure allows limiting those rights if the reason is legally justified, such as privacy rights, right? Latvia's Banka submitting the evidence requested to the district court requested by the court asked to prevent the parties from familiarizing themselves with the submitted materials. In other words, the parties couldn't see it, and to return the requested data to Latvia's Banka or destroy it. Now the district court returned the data to Latvia's Banka, and the court says overall the action on the district court is inconsistent with the law because this was not necessarily an exception justified by the law. Since the evidence was not attached to the case file, the Supreme Court also has no opportunity to check whether the district court has assessed it in accordance with the law, because it said, you know, you don't have to show it to the parties, but at least leave it in the file so that the Supreme Court can have a look at it. They mention violations are grounds for cancelling the district court's judgment. So the district court's cancellation of the assessment goes out, but then the Supreme Court says, let me see if I can deal with this myself, and comes to the conclusion that it cannot. It says it is primarily necessary to decide if there is a necessary correction for the use of the statistical data of the Bank of Latvia. As already mentioned, Regulation 556 indicates the need to compare risks as well. So when evaluating comparable loan transactions, collateral may also be important. The service must also agree that if the court considered that the presence of collateral is significant, it should have considered that UAB Malinvest controls the applicant's property rights to its assets, right? So the tax authorities had a point, is what the Supreme Court said. This may be a circumstance to consider to find out if it has significant comparability effect, because if it means that you do have access, then basically you can ignore whether there is collateral or not, or at least you must use the data from collateralized loans if the data from uncollateralized loans will show higher interest rates. Also, the district court has not explained why it has used data on transactions with collateral, and the disputed loans were issued without collateral. So even though the court did the right thing, quote unquote, by using collateralized data, it didn't explain why it did so, right? And it should have done so. In the judgment of the Supreme Court revokes the decision of the Administrative Court of 2018 and sends the case back for reconsideration. So I think this is an interesting decision for a number of reasons. But especially this thing about if your debtor is your subsidiary, you have access to its indirect access to its assets, therefore you don't need collateralization. And the question is whether this makes collateralization meaningless, right? And I think if we look at existing case law, one can say an argument for this would be Chevron, the Australian case, where the judge basically said, who is your true comparable? Your true comparable is not a company that has no related parties. Your true comparable is an independent company that has related parties where it may rely on parental support or it may rely on a parent guarantee for loans, right? I've discussed this case before, and you can find it in the study material. Or would you argue against? And I think against would be, for instance, the Canadian Prevost case, where the Canadian court decided that the Dutch company Prevost, which was a joint venture vehicle for a Swedish and a UK group, was the beneficial owner of the dividends it received from the Canadian company Prevost, even though there was a shareholders agreement to pay on 80% of the dividends received as soon as possible. Basically because Prevost, the Dutch company, was not a party to that shareholders agreement. And also what the court said, and this is relevant to this case, it said, if that Dutch company went bankrupt and before paying out the dividends, I mean, those dividends would have belonged to the creditors. And one can say the same here. If Rrīgas went bankrupt, then even though Malinvest was 100% shareholder, without collateral, it would not have had access to the assets of Rrīgas until the claims with priority over the loan of Malinvest have been satisfied for third-party creditors. So there are arguments for and against this statement. But I think in all cases it does mean that if the tax authorities are going to keep on following this line of thought and the courts in Latvia does the same, then all intercompany interest rates for Latvia at least would have to be at the lower collateralized rates. I would be curious to hear what you think about this question. I think two other points from here is this whole issue of that parties must have access to all the data examined by the court, and again, in that way, this case deals also with secret comparables in a way, and then the fact that there is this recent case apparently from the European Court of Human Rights on secret comparables, or at least the fact that parties must have access to the same data the court has. That would be worth looking at, because secret comparables certainly can play a role in transfer pricing cases in some countries still. I hope you enjoyed this, and I look forward to seeing you, or at least talking with you, next time. Bye for now.